A very good afternoon to you, friends. We from the Institute of Company Secretaries of India welcome you. On behalf of the Council and the President, I would like to emphasize on the importance of today's topic, which is pertaining to cyber laws. Today, we deal with everything through information technology. We use Twitter, we use Facebook, we use all the social media, and we should be aware on the repercussions of anything which is done by them on the internet. Today we have a very renowned faculty, Mr. Pawan Duggal. A brief about him. Mr. Pawan Duggal is the president of cyberlaws.net. He has been working in the pioneering area of cyber laws, cyber security laws and mobile laws. While a practicing advocate, Supreme Court of India, Mr. Duggal has made an impressive impact with an international reputation as an expert and authority on cyber laws, cyber security law and e-commerce law. He is acknowledged as one of the top 4 cyber laws lawyers around the world, as one of the top 10 cyber law lawyers around the world in WDD. His employment as a consultant and UNCTAD and UNESCAP on cyber laws and cybercrime respectively, various memberships, is also a particular pointer on his achievements in this particular area. Mr. Duggal has been associated with the Institute since we have launched various seminars in the last 1 year or so on cyber laws, and we had covered many of the cities around the country. There has been demand for this particular webcast because in the last 1 year we could cover just around 8 to 10 odd cities across India, and there was a need to reach out to more cities. So on your popular demand, we have requested Mr. Duggal to come over to the institute and be a part of this particular webinar. He is a member of Public Interest Registry.org Advisory Council. He is a member of ICT Policy and Governance Working Group of the UN ICT Task Force. He is the legal and policy consultant to Internet Mark II project, which is examining the next level of Internet. He has been associated with the Ministry of Communication and Information Technology on cyber law and electronic governance legal issue. He is a member of advisory group on e-governance in Karnataka, constituted by the government of Karnataka and various other organizations. We welcome you on this show, sir, and we hope that your guidance will go a long way in particular guiding the company secretary profession. Company secretaries by themselves were working on a pen and paper around 4 to 5 years back. With the oncoming on technology, Ministry of Corporate Affairs has initiated online processes and use of digital signatures. These days, each and every company secretary is using technology to the hilt. We would like to know from you in this particular seminar, what are the do's and don'ts that the company secretary should exercise in his profession? Over to you, sir.
Thank you, Mr. Yadav. Good afternoon. It's a pleasure to be on this webinar. So, as Mr. Yadav says, we are all in the digital format. We are all using computers, we are using communication devices, we use computer networks, computer servers, computer resources. So it's but natural to expect that as we transmigrate to the digital ecosystem, there are a large number of legal, policy and regulatory issues that you as professionals, as company secretaries practicing in India need to be aware of. So I thought, let me begin by sharing with you some perspectives on what you as a professional need to be knowing. I'm pretty confident you would all be knowing a majority of what I'm talking, but I would like to just spice it with certain case studies, with certain incidents that have happened, which have once again highlighted the need of professionals like company secretaries to be more alive of the legal ramifications of the law in India. I have a small presentation, but please feel free to ask me any questions in between. And we have this webinar. I'm looking forward to your questions and whatever little that I know, I believe we could share our perspectives. So when I talk about company secretaries, you guys are ultimately dealing with electronic transactions. And when you deal with electronic transactions, there's a need to know the nuances pertaining to cyber law, pertaining to data protection. Because at the end of the day, the raw materials that you would be using will be data and information in the electronic form. And therefore, you need to be alive of the legal ramifications that will come and visit in the context of electronic transactions, not only your client, and the promote matter. Now in this case, there was a company, and this company had an MD. Now this company is into hardcore defense manufacturing. In the end, the managing director, obviously, as per the now requirements of law, needs to have a digital signatures because the returns have to be signed. So he was not even aware that he had digital signatures till one fine day a vendor walked into his office and said, "Sir, here is a digitally signed pro note. This is digitally signed by you as the managing director. And in the digital pro note, you as the managing director have promised that your company will pay me a sum of 25 lakh rupees. I'm presenting this digital pro note. Please pay me 25 lakhs. That's for the first time that the MD came to know about the fact that he had some digital signatures. The matter was investigated, the vendor was blacklisted, we were able to sort out that issue. But more significantly, we found out that the internal professional in-house who was working for the company had gone ahead and shared the digital signatures for 24 hours with the vendor for a consideration. Little did he also realize that the vendor is going to potentially put the digital signatures on a digital pro note and come back and haunt the company with some demands for money. So the concerned professional was terminated and action was started. So this is one scenario to say professionals who are dealing with the digital signatures for clients need to be careful of the ramifications of the law. When you deal with digital signatures, you're only a custodian, you're a trustee, you're holding it in trust, and therefore the adequate responsibility of ensuring due diligence, care and caution is very, very important for you as a professional. Now, as more and more people are now using digital signatures in India, and as more and more of you professionals are dealing with the digital signatures of clients, you will need to be even more careful, because tomorrow you can't really rule out the possibility of some kind of legal ramifications coming and visiting you, thanks either to the misuse or abuse or other unauthorized use of the digital signatures per se. Well, in the second case, we had this case where a chartered accountant, while filing income tax returns, had actually done some, shall I say, manipulation in the returns and had filed it on behalf of the client, putting the digital signatures of the client. Now the client came back later, once he came to know about it, to the income tax department saying, "Sir, these are not my returns. The digital signatures are mine, but the values that are given into the returns are not mine, and please, I'm not going to be held responsible or liable for what I've stated there because my professional has done this and he's misused." In this case also a criminal case was filed and the matter continued for some time. So once again this case was a waking up reminder call that okay, you will have to be extra careful. Tomorrow the potentiality of the client coming back to us and saying, look, my data or my digital signatures have been misused is relatively high. And we as professionals have to be very, very careful that we should try as far as possible to protect our own selves from potential legal exposure. In another case, we had this, and this is now pretty regular kind of cases. We are seeing large number of cases where misuse of digital signatures of different clients, different legal entities is done while uploading ROC documentation. And now these litigations are beginning to find their way to courts, where courts are saying, well, okay, we will examine the legal ramifications of the misuse, but clearly the concerned professional who has gone ahead and physically appended the digital signatures to the ROC documentation, or who has been responsible for uploading the ROC documentation on the ROC website, he or she cannot just wash away his hands and say, I'm not going to be liable. he will be equally responsible for activities that take place. We have this case that I wanted to mention to you. This was the case of Uma Shankar. This was a case where it actually demonstrated how the law pertaining to digital signatures and more so pertaining to data protection in India is evolving. In this case, it was a typical phishing case. A bank account of an NRI got hacked. He got phished for an amount of 5-6 lakh rupees. He came back to the bank saying, "Sir, this is not my transaction. Please reverse it." The bank took a higher moral stand saying, "Sorry, you are the one person who has done it. Since you have the credentials, you have the username and password, and therefore we presume that you have done it, and therefore you cannot now resile away from this contract or this transaction." He ultimately filed up for damages under the Information Technology Act 2000, and the adjudicating officer, being a special court under the Information Technology Act 2000, actually awarded a sum of rupees 12,85,000 against the bank. The bank has since now gone up in appeal, and the matter is pending before the Cyber Appellate Tribunal. But the fact is, the case has now opened up the doors for potential liability. The question that you have to ask yourself, or your clients have to ask themselves, or you have to ask your clients, does your or their business deal with data and information in the electronic form? These are important questions. They may look very, very simplistic, very primer, but these are fundamental to the way how the law will be applicable to you. Does your company provide mobile phones, smartphones to its employees for doing business? And you will begin to say, well, okay, I do that. I've got my practice. I'm into this company. Our company is doing that. So what? Let's go further. The fact is, any kind of phones that are now provided are recognized under law as communication devices. In fact, Section 2 of the Information Technology Act 2000, after amendments in 2008, have actually defined the term communication device in very vast terms. It includes not just a mobile phone, a cell phone, a personal digital assistant, a combination of a cell phone or personal digital assistant, as also any other device which can be used to communicate audio, video, image and text. So clearly, anything and everything that you can think of digitally is being brought within the ambit of the law in the context of communication devices. Right? This webinar is taking place, and I'm addressing you through a camera, through the computer networks, ultimately onto your computer system. All this is also nothing being done but exercises being done using communication devices in India per se. So the thumb rule is that there's already a cyber law in place. This is the Indian cyber law, the Information Technology Act 2000. This is applicable to everybody in the country who uses any of the 7 raw materials in the digital or mobile ecosystem. So if you use computers, computer systems, computer networks, computer resources, communication devices, as also data and information in the electronic form, ladies and gentlemen, you get covered under the cyber law. This is a law that India had enacted way back in the year 2000. In fact, it's pretty strange. Those days when we enacted the law, nobody had the faintest of ideas of how this law is going to evolve substantially over a period of time. So much so that it has now evolved from being a small sector-specific legislation, being a legislation aimed for promoting e-commerce and electronic governance, to now becoming the mother legislation that India has pertaining to the digital or mobile ecosystem. Everything in the digital format gets covered. Of particular relevance is Section 81 of the Information Technology Act 2000, which categorically says that the provisions of the Information Technology Act 2000 are special in nature. And in the event of any conflict between the Information Technology Act 2000 as also any other law for the time being in force in India, the provisions of the Information Technology Act 2000 will have superseding effect and will proceed over the application of other laws. So clearly, it is provided any conflict between any laws, sectoral laws, general laws, and the IT Act shall prevail. Therefore, you as professionals need to be particularly well aware of what the nuances are. You don't need to be lawyers, but since you are dealing with data and information in the electronic form for and on behalf of your companies, your clients, your employers, you will have to quickly go ahead and understand the legal nuances emanating out of cyber law. In fact, this is a law that I would akin to a typical Bollywood masala film. Like a typical Bollywood masala film has got various elements. It's got action, romance, comedy, drama. The IT Act also has a combination of a variety of elements. The Information Technology Act has elements to deal with electronic commerce propagation. It deals with providing the legal frameworks for granting legality to the electronic format. It's provided the frameworks for electronic governance. It's provided an element and some chapter on cyber crimes. And it's gone ahead and defined the liabilities and the roles and responsibilities of network service providers and intermediaries per se. Broadly speaking, one of the biggest achievements of this law has been that this law has granted legality to the electronic format, in the sense that whatever you now do in the electronic format has been given the same sanctity or same validity as you do on the paper format. So, in fact, the amendments to 2008 go ahead and further clarify that there will be no discrimination against the electronic format per se, and that's really provided the basis for e-commerce and m-commerce to subsequently grow in India per se. The law has also now gone ahead and provided a basis for electronic filing, and this filing is important because today more and more of us as professionals, us as citizens of India, are going ahead and dealing with the government electronically, whether it's the ROC, whether it's in certain brackets, the filing of income tax returns. Everything is now being done online, and therefore it has actually facilitated the legal frameworks which have granted legality to electronic filing by citizens of India with governmental and non-governmental agencies. It's legalized that and provided the legal frameworks which will govern all electronic filings in India. The Indian Information Technology Act 2000 is also significant because it's gone ahead and amended 4 different laws of the country. The Indian Penal Code, the Indian Evidence Act, the Bankers Books Evidence Act, and the Reserve Bank of India Act. These are all distinct legislations which had an impact on the electronic ecosystem, and therefore the IT Act said, let's go ahead and amend these as well. All electronic records are now legal. All your emails, Facebook messages, tweets, Instagram photographs, your SMSs, whatever you can think of in the data or information in the electronic form is now all legal, can be used as evidence in a court of law in India. Of particular relevance now is from the perspective of us as professionals, the issue pertaining to electronic authentication. And here I want to read this particular section which talks about digital signatures. It says, subject to the provisions, every person, a subscriber, may authenticate an electronic record by affixing his digital signatures. And the authentication of the electronic record shall be effected by the use of asymmetric crypto system and hash function, which envelop and transform the initial electronic record into another electronic record. So all these digital signatures are being issued and they have been granted legality. The explanation under the law says that for the purposes of the law, hash function means an algorithm mapping or translating a sequence of bits into another, generally smaller set known as hash results, so that an electronic record yields the same hash results every time the algorithm is executed with the same electronic record as its input, making it computationally infeasible to derive or reconstruct the original electronic record from the hash result produced by the algorithm. That two electronic records can produce the same hash result using the algorithm. Any person, by the use of the public key of the subscriber, can verify an electronic record, and more significantly, the private key and the public key are unique to a subscriber and constitute a functioning key pair. So when you are using those digital signatures, that's been possible thanks to this particular law and thanks to Section 3 of the Information Technology Act 2000. So what does that mean? You can use all digital signatures? Yes. But if you are in India, please go ahead and use digital signatures which are issued by duly licensed certifying authority who have been issued a license to issue digital signatures by the relevant statutory authority under the Information Technology Act 2000, being the controller of certifying authorities. If you use other digital signatures or private digital signatures which are outside India, they can be good for security purposes, but they won't be good for legal purposes. In fact, any kind of a digital signature has twin function. It either has a security function or it has a legal function. When you use a digital signature which is issued by a duly licensed certifying authority in India, then your digital signature fulfills both the security function as also the legal function. But if you use any of the outside India's digital signatures which are not issued by agencies who are duly certified or licensed under the Indian law, then that digital signatures may be valid and may serve the security function, but will definitely not go ahead and serve the legal function, since those digital signatures are not now legal in the country per se. Another significant aspect of the Indian cyber law is that it's granted legality to electronic contract. You can make an offer electronically, you can accept an offer electronically, and the moment you accept an offer electronically, it results into a valid binding electronic contract. The same has been granted legality under the law. Digital signatures are now legal. In fact, the law says digital signatures is just as the same as putting your own signatures on paper. Therefore, there's no distinction between using your digital signatures versus using your physical signatures on paper. Both have been granted equal legality, and courts are now increasingly upholding the significance of digital signatures. Earlier, the law, I think you wanted to say something, please.
Actually, we have received so many questions.
Okay, so let's pause here and let's answer all these questions.
That'll be great.
Sure.
The company secretary is on the board of the management, and one of the questions is that the cyber security is discussed like anything on the board. But what is the strategy which the board should adopt, or what are the strategies which the company secretary can suggest to his board so that there is a security aspect on all digital matters pertaining to the company? He's talking something about a policy framework. So what are the policy framework, or there are some ready-made policies which he can imbibe? This is the precise question that first person is asking.
Thank you. That's a very, very pertinent question. Today, cyber security is the de facto most hot topic across the world, and every country is concerned, including companies. That's primarily happening because cyber criminals have become pretty indiscriminate. They go ahead and attack companies, they go ahead and steal their data and their databases, and somehow prejudicially impact their intellectual property in the various digital assets that they may have. Therefore, as a company secretary, when you're called upon to advise your board, please ensure your board, by advising them, that your board and the company must comply with the Information Technology Act 2000. In fact, in 2008, the IT Act was amended and we inserted a relevant definition on cyber security, which is very, very vast. If you look at Section 2 of the Information Technology Act, you will see it's a very, very vast definition. Now, pursuant thereto, the Government of India has notified various rules under the Information Technology Act. These are the Information Technology Intermediary Guidelines Rules 2011 and the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data and Information Rules 2011. Now, as per these rules and as per the IT Act, your company, when it provides internet connectivity, today all companies provide internet connectivity, email to their employees. The moment you do that, you become an intermediary under Section 21W of the Information Technology Act. The moment you are an intermediary under Section 79(2)(c) of the Information Technology Act, you are required to exercise due diligence while you discharge your obligations under the Act. Now, as part of due diligence, the government has now specified various parameters. Now, one of the elements of due diligence is that you must take appropriate steps to protect the veracity of data that's residing on your computer systems and computer networks. So therefore, all intermediaries and all companies in India are now mandated by virtue of the Information Technology Rules 2011 to have in place reasonable security practices and procedures when they go ahead and deal with or process third-party data. Now today, any company is dealing with a lot of third-party data. It could be of their clients, of their customers, of their projects, a variety of data that does not physically belong to them but belongs to someone else. So in that context, the law wants the boards to implement reasonable security practices and procedures. Your next question, what are these reasonable security practices and procedures? The law has further gone ahead and said an ISO 27001 is one such instance of reasonable security practices and procedures. So please tell your boards that ensure that you comply with reasonable security practices and procedures, have in place an ISO 27001. You can either get yourself certified, but even if you don't want to certify, at least follow the basic principles behind the same. And number two, have in place adequate terms and conditions, rules and regulations, privacy policies, and IT security policy, which are mandated by various provisions of the Information Technology, Reasonable Security Practices and Procedures, and Sensitive Personal Data and Information Rules 2011. All these are mandatory compliances that you must do. You must advise your boards and your company. And in case if you are now in the banking sector, then you have to wake up. Why? Because on 2nd of June 2000, on the first week of June 2016, the RBI has come up with a mandatory now directive directing all banks in India to have in place a cyber security policy. And that policy must be so drafted keeping in mind the specific recommendations of the G. Gopalakrishna working group. So you need to put all of these in place. So the focus is coming back on compliance, compliance and compliance. Please get your compliances done under the IT Act, rules and regulations, and that will help you substantially to achieve the minimum level, the minimum parameters that the law expects your company to do in the context of protection and preservation of cybersecurity.
Great, sir. Because the company secretary is known as most of the time it's known as the compliance officer also. There's something pertaining to data protection. We actually talked about it. There is no such law in India on data protection like in many European countries. This is one of the viewers feel.
Sir.
Even our cyber cells are not fully aware of any advanced technologies. Many countries are taking measures, but there are no strict laws in India.
Right.
What's your view on this?
I think you're bang on target. The fact of the matter is India does not have in place a dedicated data protection law like the European Union has. So consequently, we begin to start feeling that our data is not so secure. And there's a historical reason for this. India has primarily originated from a society that came from joint families. Sharing was a way of life. Consequently, Indians did not give that much kind of a primacy or significance to data protection as was given in the West. So consequently, we decided not to have a dedicated law on data protection, but we had some provisions impacting data protection under the Information Technology Act 2000. There's been a lot of pressure on the government that you need to have in place a dedicated law on data protection. Well, some elements are covered under the cyber law, but that's not adequate. And now with the Internet of Things coming in, with cyber security breaches happening on a regular basis, the significance of data protection law becomes very, very relevant and material in today's aspect. I believe this new government is working on some new laws, and hopefully we should potentially see some dedicated law on data protection, because if India wants to be an IT superpower and we want to transform India into a knowledge society and economy by the year 2018 under the Digital India program, India distinctly requires a dedicated, specific and specialized data protection law.
Okay. I'll actually pick up only the questions pertaining to data security. What are the applicable sections which companies should adopt if there is a theft of data by an employee? What is the remedy in case of deleting data by the employee?
Fantastic. This is a wonderful question, because this is a practical problem that almost all companies are facing. Somehow this can be originating from the mindset that exists of employees. Somehow employees feel that whatever data that they have access to on corporate networks is their own property. They pick it up, they take it on pen drives, send it via personal email accounts, or now simply take photographs on their mobile phones and use it or transmit it using WhatsApp. So if your company finds that it's a victim of such an exercise, the first thing is that being silent is not an option. You will have to take action. So what are the various options? When a person steals data, your employee steals data from your corporate networks, you can have in place two remedies. One is a civil remedy and the other is a criminal remedy. The first thing is, please report the matter to the law enforcement agencies, because when a person steals data from your corporate network, it tantamounts to various cybercrimes under the Information Technology Act 2000, as also under the Indian Penal Code. For example, it's distinctly theft under section 379 of the Indian Penal Code, since your electronic data is movable property. More significantly, these are also computer related offences under section 66 of the Information Technology Act. Why? Because the employee, when he does these exercises, he does it dishonestly or fraudulently. He does that without the permission of the company or the person in charge of the computer system or computer network, and he actually does the physical act of downloading, extracting or taking out information from corporate networks. That becomes a specific offence under section 66 read with section 43B of the Information Technology Act 2000. In addition, when he takes your corporate data, that actually tantamounts to diminishing the value and utility of your corporate data, often without your knowledge or permission, and that's obviously done dishonestly or fraudulently. That being so, that's a separate offence under section 66 read with section 43I of the Information Technology Act 2000. In fact, that's a remarkable section. It says any activity which tantamounts to diminish the value or utility of electronic information can be brought within the ambit of criminal liability. That's the first thing. Of course, it's a criminal breach of trust. You can invoke section 408 Indian Penal Code. You can also invoke various other sections, including conspiracy and common intention. So 120B and section 34 can also be invoked. But that's a criminal remedy. That's part one. Part two is the civil remedy. Once I know that he has taken the data, I obviously want as a company that he does not go ahead and misuse the same. So I need to go to my court of competent jurisdiction and get an injunction against the guy because your data is your proprietary information, your digital assets on which the intellectual property rights belong to your company per se. So when he takes away your data, he not only commits an offence under section 63 of the Copyright Act, because that's a case of infringing your copyright, but more significantly provides you the ground that you can sue him for injunction and damages. And routinely now courts grant injunctions directing the employee not to misuse or sell or create third-party interest on such data. In addition, you can also seek for damages. Apart from that, there's a third element, a third bucket. And the third bucket is another remedy that you have under the Information Technology Act 2000. Under section 43 of the Information Technology Act 2000, you can ask from the employee specific damages, statutory damages under the IT Act, which can be up to 5 crore rupees. For that, you don't have to go to normal court of law. You'll have to go to specialized courts. These are known as the courts of the adjudicating officers. These are the IT secretaries in different states. They are mandated to ensure that they complete their entire proceedings in 9 months, 6 to 9 months. And that's one other remedy. And in case if you feel that your loss is beyond 5 crores, then you can actually sue for damages under section 43 of the IT Act beyond the 5 crores in a court of competent jurisdiction. So you have these three distinct remedies. My personal opinion is, please encourage your companies to ensure that they go for all these three remedies and then ensure. A lot of times what happens is that these matters would tend to get compromised. The company may not want to report. They feel reporting may prejudicially impact their reputation as a secure company. Now that's a business call that you need to take. But since offences have taken place, I think you should definitely report, and in addition, you should go ahead and seek injunction against the erring employee.
Great. I'll just take two more questions which
Sure.
are pertaining to data.
Sir.
In the course of work, we share data with our vendors and we always sign a non-disclosure agreement with such vendors. Does these particular non-disclosure agreements are a valuable agreement under the law?
All non-disclosure agreements are completely valuable legal agreements under the law. So please don't routinely sign them. Please read the terms and conditions. See what all exactly are they asking you not to disclose. Because a lot of times what happens is companies and vendors invariably would want you to come and sign very vast non-disclosure agreements. And often you would sign without reading the same. And subsequently you'll realize that there's a problem, but because you signed the NDA, you're not in a position to go forward. So I will just encourage you to read the terms and conditions of the non-disclosure agreement, but please ensure that only sign when you are satisfied, because these are legal documents, can be completely relied upon in courts of law.
Okay. Now this is pertaining to personal data which is held on servers within India and outside India. So how does the implication of law change if this data is held within India or outside India? Does the law distinguish between the two of them?
In fact, the law does not make any distinction between your data whether located inside India or outside India. The moment you as a company are dealing with electronic data, you get covered under the Information Technology Act. Now the IT Act is remarkably different from other legislations. Majority of legislations in India are of a territorial nature, that they will only apply within the territorial boundaries of India. But the IT Act, by virtue of Section 1 and Section 75, has given extraterritorial applicability and jurisdiction to this law. In fact, the IT Act categorically says that this law applies to any person of any nationality, anywhere in the world, so long as his services are available or are impacting on a computer system or computer network physically located in India. So even if your data is outside India, the Indian law will thoroughly be applicable both upon you as a legal entity as also your service provider which is hosting your data outside the territorial boundaries of India.
This is one question actually which I think every company secretary does in his working. He says, can we take general authority in writing from director of company to hold his digital signature and use the same digitally to sign ROC forms and returns NS when required?
Lot of time professionals come and ask me this question. There are no golden principles. You can try to take that authority. My only problem is that's not going to serve you well, because if it's a general authority, the client or the company can still come back and saying, though I had given you this general authority, I did not give you the authority to append the digital signatures at this point of time on this electronic record. So the chances are that whenever you are using the digital signatures of your company or its management, please ensure detailed legal authorizations which authorize you the specific activities for which they are to be used. General authorization will be like a general power of attorney which the courts may or may not be inclined to really uphold. Because when I generally say, here is my digital signature, go ahead and use it in any way, it's a very, very dangerous phenomenon because I'm effectively giving you my own identity. So that being case, the courts are very clear that these kind of general permissions or authorizations may not work. If you are a professional, obviously you want the access for a limited purpose. So if your authorizations can specifically define what are the specific activities for which this will be used, and then you can take that authorization, then I think it can still hold you good, because then it will show that whatever you appended, the digital signatures, were only for the limited activities which were specifically given in the special authorization. So to that extent, I will not advise you that you get a bigger authorization like a general power of attorney. I would rather more go in the direction of a special power of attorney or a special authorization which specifically authorize you to do limited 3, 4, 5, 10, whatever things, activities that need to be done in the context of digital signatures. Such kind of an authorization will not only protect you, will protect you from potential legal liability in the times to come, and could also be potentially upheld, because once the guy has given you specific authorization, he tomorrow cannot come back and say, I was misled. No, you were intelligent enough, you did not give the complete authorization, the general authorization. You only said for these 4 things, use my digital signatures. Now once these 4 things, you as a company secretary use the digital signatures, he cannot come back and fault you for that particular purpose. However, please remember, that does not stop him from initiating proceedings against you. It's a different matter that you will have a good defense if you have some authorization. But the potentiality of the client creating a nuisance for you is already existing. So therefore, please have in place adequate paperwork. Do not just blindly believe anyone, your companies, your management, your clients. Why? Because tomorrow, when push comes to shove, there's a possibility that the company may say, well, the professional did it, we had no role to do with it, and then let the professional face the fire. Somewhere down the line, the professional needs to have in place adequately legally defined authorizations and documentations which can help protect him from potential exposure to legal liability.
So there are so many questions on digital signature. So I think we'll let you complete on the digital signature part and then raise those questions.
Sure. Okay, I think we'll come back. We were talking about digital signatures. In fact, earlier when we enacted the law in the year 2000, we had a very small focus. We only wanted the law to promote electronic commerce, and for that digital signatures was important. So the law gave legality to digital signatures. One of the criticisms of the law was it was a technology specific law, in the sense it had only authorized and allowed one particular technology for digital signatures, being a symmetric crypto system and hash function or public key infrastructure technology. Now, by the time the law got to be amended in the year 2008, the government took into account this particular criticism and said, okay, let's now expand the scope of electronic authentication. Why? Because while digital signatures are still the de facto mode for electronic authentication, the chances are tomorrow we are going to see more and more biometric and other kinds of authentication processes. So therefore the amendments to the IT Act, being the Information Technology Amendment Act 2008, brought up with a new concept, a broader concept of authentication known as electronic signatures. And this is how they defined. It says electronic signature means authentication of any electronic record by a subscriber by means of the electronic technique specified in the second schedule and includes digital signature. Now, digital signature is already part of electronic signatures. The government has been given the power to specify the various parameters for authentication on the second schedule. As on this afternoon, the government has not populated the second schedule with any entry. So effectively it's a digital signatures. But in a nutshell, if I could say that the electronic signatures is like an umbrella. And under the umbrella, one small component is a digital signatures. Tomorrow, there will be authentication using your biometrics, your iris, your fingerprints, your voice recognition, your facial recognition. So the chances are that all these may become potential parameters for electronic authentication. So the law has now been drafted in extremely futuristic terms so as to incorporate any future available exercises of authentication that may become more and more relevant for electronic authentication as the time passes by. Of course, the word digital signatures has been defined to mean authentication of any electronic record by subscriber by means of an electronic method or procedure in accordance with the provisions of Section 3 of the Information Technology Act 2000. And of course, if you talk about 3, this is again talking about a symmetric crypto system and hash function that we talked about earlier per se. So the fact remains is whatever digital signatures that you are getting in the market today are simpliciter digital signatures which are issued in India by duly licensed certifying authority who have been duly granted a license to issue digital signatures by the relevant statutory authority being the controller of certifying authorities. Increased use of digital signatures in filing income tax returns, filing of documentations with the ROC, Ministry of Corporate Affairs is all happening, and we are doing this on a daily basis. So we will have to be very, very careful of the nuances pertaining to use of digital signatures. In a nutshell, what does the law say? The law says, this is my digital signature, this is my identity in the digital form. If this is going to be misused, I am going to be held responsible for it. The law says, if I don't report a misuse, till such time I don't report, I will be liable for any misuse or abuse of digital signatures. But once I report either to the police as also to the controller of certifying authorities, then the clock stops ticking. My liability comes to close. Once I have reported, after that, the law cannot make me liable for any misuse because I have already reported the matter. So the moment any digital signatures get lost or get misplaced, the first thing is to immediately report to the police. Also, please send an email on the website of the relevant statutory authority being the controller of certifying authorities, and then your exposure to potential legal liability comes to a halt there and then. But if you don't report, then till such time you don't report and any transactions keep on happening, then you yourself would be responsible for the misuse of digital signatures per se. So various rights, duties and obligations of subscribers have been given. Subscribers have been specifically mandated to exercise due diligence, caution when they are dealing with digital signatures. Ideally speaking, your digital signature should not be shared with anyone. Why? It's your own identity. Somebody can misuse it. But because of the exigencies of time, business, or convenience, we don't have the bandwidth. We invariably give it to the professional. Here's the company secretary, sir, please take my digital signatures. Do it. Why? Because I don't have the time. So you are effectively intrinsically trusting the company secretary. But that trust must be documented in documentary terms. Because in case if there's a misuse and there's no document to actually document the authorization of the use of digital signatures to the company secretary, potentially the client is likely to be on a much more stronger legal wicket in this regard. And therefore, you have to be more careful. This is the relevant statutory authority which has been made responsible for all electronic authentication in India. This is the controller of certifying authorities. This got created by the Information Technology Act 2000. This is the relevant authority that grants licenses to all digital signatures issuing, certifying authorities in India per se. There is somebody known as a controller of certifying authorities. This particular person, I call him the Superman under the Indian cyber law, because he's been given huge amount of powers. He has been made responsible for vital functions concerning electronic authentication, which are extremely imperative for the proper implementation and running of the digital signature, as also the electronic signature regime in India. And of course, he has been given the powers to investigate any contraventions under the Act, including any contraventions of misuse or abuse of digital signatures or otherwise that can take place. And specific proceedings before him takes place under Section 28 of the IT Act. Well, I think you have to quickly realize that the law has now gone further and provided for various penalties. So if digital signature gets misused or abused, then effectively has been brought within the ambit of criminal penalty. It's a cyber crime. So if you misuse somebody's digital signatures, it gets you 3 years jail time, plus also fine. If you fraudulently append the digital signatures on any electronic record which you know is false or has been done for fraudulent purposes, that gets you another jail time. So a number of cyber crimes have been given in chapter Roman 11 of the Information Technology Act, which specifically deal with use, misuse or abuse of digital signatures, and they are punishable with imprisonment of 3 years and fine and a variety of other stuff. So I think you have to quickly realize that the IT Act is based upon the concept of personal liability for offences and penalties rather than corporate liability. That does not mean that corporate liability will not be there, it will still be there, but the individual who misuses the digital signatures, his personal liability will definitely be on. So the thumb rule is the IT Act says be very, very careful on all your activities done using computers and space. Before I go to cyber crimes, I can now pause for the questions.
I think I'll take up only the digital signature issues.
Sure.
You used the word misuse or conceiving fraud. So how does it distinguish between the misuse in terms of digital signature, one, knowingly and unknowingly? Now, if it is knowingly, then it could be considered as a fraud. If it is unknowingly, then does the law protect you or does not protect you?
The law, unfortunately, is blind. So the law has said misuse is misuse, and misuse has been defined to basically mean unauthorized use. So therefore, coming back to our previous discussion, please have in place specific authorization. If you have specific authorization, then your use of the digital signatures for the client or for the company or top management will neither be unauthorized nor it will be termed as misuse, because you have an authorization. But if you don't have an authorization, then tomorrow the chances are that the company can say it's misused because we did not authorize in writing. So the focus under the IT Act, specifically Section 43 of the IT Act, is on written confirmation, written authorization. Verbal authorizations don't work. It could be an email, it could be an SMS, it could be an MMS, it could be a messenger chat, it could be a Skype message, it could be a Facebook message, it could be just about anything, or it could be physical paper. Once you show something that the client has authorized you or the management has authorized you, then your usage of the digital signature becomes authorized. It's no longer misused. Now, in case if you don't have any such authorization, then the question will be, it will be definitely deemed to be misused. The question is, shall it be deemed to be intentional or unintentional? Now, if you are a company secretary, you are an educated person, you are expected to know the law. In fact, you are the compliance officer. So, as a compliance officer, if you are using the digital signatures of a client or of the company or the top management, and that's without authorization, the chances are that the law is going to believe that your usage is intentional. And if it's intentional or deliberate, then you go into a different parameter altogether. You say it's not intentional, you will have to prove it's not intentional. But what kind of an evidence will you show to that your usage is not intentional or deliberate? Practically speaking, in the last about 16 years, we have found that it's very difficult to show that your usage of digital signatures has been non-intentional, because there's no surrounding circumstances. It's your word against theirs. So oral testimonies don't have much value. So I will suggest that since the blindness of the law in not making a distinction between misuse, it will be imperative that company secretaries need to protect themselves, get specific written authorization. In fact, when you read the opening line of section 43, it says if any person without the permission or of the company or the person in charge of its computer system or network, permission has to be in writing. Authorization has to be in the written format. Now, if you only choose to get permission on email, ideally it will be best if you get your email which is digitally signed, because tomorrow the other party will say, sorry, my email was sent, but I did not send it. It was not digitally signed. But if you have a digitally signed electronic document which authorizes you to, shall I say, use a digital signatures, that's wonderful. If you can have a paper document and have a paper signature, wonderful. But if you have only an email, a WhatsApp message, a Facebook message, you can rely upon it, but except you'll have to realize that in the event tomorrow the client disputes it, you would be now required to go ahead and prove that this email, Facebook Messenger, tweet or WhatsApp message has not been tampered, altered or manipulated in any manner whatsoever, which means that you will have to now give a certification under section 65B of the Indian Evidence Act, basically certifying the manner how you've taken the computer output and further certifying that the said computer output, being a printout or on the CD or on the pen drive, has not been tampered, altered or manipulated in any manner whatsoever. So that substantially increases, shall I say, your headaches, and more significantly puts more onus of proof on you. So best thing is get a physical paper, get them to sign, or get them to sign electronically and put their digital signatures authorizing you, and you're done. Otherwise, in almost all of the cases, you will be grappling with issues pertaining to use, misuse, abuse or unauthorized use.
Next question pertains to that the digitally signed documents in India, are they considered valid in other countries also?
All digitally signed documents in India are valid in India under Indian law by virtue of the Information Technology Act 2000, and that being so, since it's valid in India by virtue of the applicability of the Indian law, it's considered valid in the other countries as well. Of course, you will have to show that your said electronic records have been digitally signed by digital signatures which are issued by a duly licensed certifying authority.
Okay. Digitally signatures are issued by recognized certifying authorities. Then what is the need of registering digital certificates wherever they have to be used? For example, in MCA portal they have to be registered first. So why there is a need when they are already issued by a certified agency?
Well, this is a kind of a two-tier process that we see in the country. Your digital signatures are issued by the certifying authority who's licensed. They give you these digital signatures. Okay. Now, when I want to use these digital signatures on, say, ROC website or any other website, I'll have to first go and register my digital signatures. Why? Because they want to make sure that the digital signatures that you are saying is yours is indeed the same that's been allotted to you by the relevant certifying authority who has actually been granted a license by the Government of India. So they want to do that backup checkup. That can only be done by checking through the public key details which are available on the website of the relevant certifying authority. So that's why it's invariably done. It's more done out of caution, out of due diligence. Practically speaking, the law does not really require registration. The IT Act only says once you have a digital signature, it's done. You can continue to use it anywhere with or without registration. The word registration is absent under the IT Act. Yes, you will have to register with as an applicant with the certifying authority at the time when you apply to them for getting a digital signatures. But once you are having a digital signatures, you are ready to fly. But I think these requirements for registration are invariably done because of added layers of caution, due diligence and precautions that various departments want to keep in mind. They want to basically minimize the chances of misuse or abuse of digital signatures to the barest minimum extent possible.
Now, this is a very, I think, question that the client uses two digital signature, one of which is lying always with the particular practicing company secretary. So, what are the implications against the client and what are the implications against the person who is having one copy of this digital signature for use on behalf of the client?
This is a very, very serious question, and if you're dealing with this, I'm actually going to say, your red flags, your antennas must go up. Technically speaking, the law has a presumption that whenever a person applies for a digital signature, he will only be given one digital signature. Why? Because I'm Pawan Dugal, so Pawan Dugal needs to be given one digital signature. However, it's been brought to the attention that number of people apply and do get various number of digital signatures. In fact, I read a report that there was a guy who had 90 digital signatures in India, and he had collated that under different collations. There was some report to the internet. But the fact is, if you are aware of the fact that the guy has got two digital signatures and you as the company secretary have one and the other guy has another, I think that's dangerous phenomenon. You as a company secretary should instantaneously please go back and give the digital signatures back to the concerned person. Why? Because tomorrow, here is a case of two digital signatures. It can have a variety of permutation combinations. It can have huge kind of humongous repercussions. Technically speaking, the second digital signature can be seen to be obtained fraudulently. Why? Because a person is presumed to only have in place one digital signature. But if he's actually having a second one, he's obviously obtained that by misrepresenting his details to the certifying authority. That being so, the concerned person has already committed the offence of electronic forgery. He has forged electronic records, he's misrepresented records and got a digital signatures by way of misrepresentation, fraud, and of course further goes and uses it for fraudulent purposes. That becomes a separate crime both under the IT Act as also under the Indian Penal Code. Under the IT Act, it gets you 3 years jail time, 5 lakh rupees fine. Under the Indian Penal Code, it actually is a much more severe offence. It's been forging of electronic records for the purposes of cheating, because you're cheating the certifying authority and the controller of certifying authorities before you got the second digital signatures. So that's a separate offence, gets you 7 years jail time and fine. So this is not only the person getting it, but the individual company secretary could also be seen to be abetting, conspiring in the commission of a variety of these crimes, and the chances of you being sucked in as a co-accused in these kind of proceedings become very, very high. So the first thing is immediately return back this digital signatures if you are in the knowledge that there are two digital signatures, because that's like red hot fire in your hands. Why do you want to deal with it? Better thing is to be safe rather than to be sorry at a later stage. But in case if the client has not disclosed it to you, then it's his funeral, because you will get his appropriate authorization in writing, and then if in his authorization he is not even shown or disclosed any information, then I think the client will have to primarily be responsible to face the music under the law. But this is very, very dangerous phenomenon. We as professionals, as company secretaries, must ensure that we should not be conspiring or abetting in the commission of any cybercrime. If we do so, or any of our acts can be seen to be tantamounting to do so, then we are going to be liable as a co-accused. We are going to face exactly same prosecution criminally as the client, and not only our future looks to be in dark, my license could be suspended, I could go behind bars, my entire future could be completely prejudicially impacted. So I think it's best to be safe than be sorry in these circumstances.
Okay. Now there are situations pertaining to MNC, and this question is coming back again and again.
Sure.
That the data of MNC are sometimes held on the servers in India, whereas data pertaining to the company in India are held in servers which are outside India. I think you have already explained that the law does not distinguish between the same. Right? So the questions pertaining to same are covering, which I come back again, are Does Indian IT Act covers non-Indian data also? One. Other is I think that's all pertaining to this particular non-Indian.
Okay. So the Indian law is very clear. It does not make a distinction between Indian data or non-Indian data. It is only bothered about data which is available on or which gets impacted or which can be accessed using computers, computer systems or computer networks physically located in India. So quickly, even if it's non-Indian data, but it's available on computers in India, it will still be governed by the information technology. This is thanks to section 75 of the Information Technology Act 2000.
The three short questions. Which authority deals with cyber crime at district level in India?
The authority dealing with cybercrime at the district level is the police inspector. In fact, under the IT Act, earlier, all cybercrimes could only be investigated by police officers of the rank of a deputy superintendent of police. But the 2008 amendments actually changed the scenario and said from 2008 onwards, all police officers of the rank of an inspector above can go ahead and investigate, prosecute cybercrimes after registering the same. So your local police station having a local police inspector is authorized to go ahead and deal with cybercrime. In case if you are in an area where there's a specific cybercrime cell, then you can also go to the cybercrime cell. But if you don't have any such facility, any police station, any police officer of the rank of an inspector is authorized under the IT Act for investigating all cybercrimes.
This is a very generic question, I think a very layman's question also. How do I save my bank account from being hacked, number one, and what are the precautions? How much time I should check it to avoid any financial fraud?
This brings us back to the fundamental issues of some key good hygiene habits to ensure that you don't get hacked. First and foremost, you must consider your passwords to be sacrosanct. Do not share them with anyone. When I say anyone, not even your family members, not even your friends, nobody in the office. Number two, you must use alphanumeric passwords. Don't make passwords which can be guessed, the names of your family members or the birthdays or stuff like that. Have a combination of alphabets and numericals so that it becomes hard to guess. Number three, do not access any of these username passwords on cyber cafes. Today, more and more people use their own mobile phones, but in case if you are using cyber cafes, you have to be mindful of the fact that large number of machines in cyber cafes now have a lot of spyware and malware. So be careful of that. Number four, when you are doing a banking transaction, please do not go in showmanship or showing off. Keep your banking limits small. Why? So that even if your account does get hacked, your exposure becomes relatively less. Ensure that you check your credentials or your banking account statements every second day. Go for an SMS kind of a service so that any transaction done, you get an SMS. The moment you find a transaction is not yours, immediately report. Don't be silent. Report to the bank, report to police. In addition, have a good antivirus on your laptop or on your mobile phone. Also, have a good firewall so that unauthorized intrusions can be prevented. But more significantly, you have to ultimately inculcate a culture of cybersecurity. You will have to be conscious of the fact that your money and your data is as good as your data. So therefore, your data is equal to money. Please do not share your confidential data, usernames, passwords, credit card details, debit card details, internet banking details, or any confidential information or sensitive personal data with anyone. Once you're able to have these basic hygiene habits, I think to a large extent you can ensure that you can be relatively safe from hacking. You cannot be absolutely safe from hacking. In fact, there are only two kinds of people in the world. First, who know that they have been hacked. Second, who do not know that they have been hacked. Everybody has been hacked. Everybody can be hacked. And therefore now the focus of the new discussion is we will take it for granted that we will be hacked. The issue will be how quickly can we be cyber resilient. How quickly can we come back? So the moment you are alive of these nuances pertaining to cybersecurity, the moment you can be realizing that you can be the weakest link of the chain, I think you immediately start taking quantum steps forward to protecting yourselves, your bank accounts and your data from unauthorized intrusion and from hacking.
Now, many companies are using Google servers or Google business solutions for email communications. Google terms and conditions specify that they shall have access to the text of email and the attachments also. Now, the question is that how much of it is a threat, because Google has access to your text and emails. So, how much of it is a threat, and can Google be prevented from accessing such corporate data?
The answer to your first question, Google can be a big threat. Google today knows you more and much more better than your wife, your father, your mother, your girlfriend, your boyfriend, if you're using Google services. Why? Because they know everything about you. They can map you. So the idea is, if you want to use Google services, just pause and read the terms and conditions. Read the privacy policies to get an idea of what they do with your data. Google is a data company. They only deal with your data. So they're only concerned with you as data entities. Therefore, they would be using all of that. And all these terms and conditions, when you agree before you create a Gmail account or use any of the Google services, you actually authorize and you permit Google to do all these activities. So if you think you don't want to have any service provider doing this, the best thing is not to touch Google services, because Google looks at all your data in a 360-degree angle. They map you out. So can you prevent them? Well, you can't really prevent them because they are offering a voluntary commercial service. Its choice is yours. There's nothing, a bullet that's being put on your head and say you must take Google. Don't take Google, take other people. In fact, if you look at now the trend, more and more people are now not wanting to use Google services. Why? Because Google is now mapping you in every moment, your physical location, your personal information, your transactions. If you look at some of these new Google applications that have come in, they will now actually be coming back and informing you and reminding you, Pawan, you have a flight at 4 o'clock. Why are you still here? It's going to take 1.5 hours to go from here to the airport. Now, when they are mapping your life to such an extent, and a lot of that will be personal information, I think you need to be careful. So if you don't want to be surveilled upon, you don't want your data to be misused or unauthorizedly accessed by service providers, go in for encrypted service providers who provide encryption levels, which are higher levels of protection and which ensure that your data cannot be read by them.
Sir, we'll take the questions thereafter, after you have completed the next topic.
Okay.
Because they are regarding preservation of evidence.
Wonderful. So that evidence ultimately deals with back to criminal activities or with unauthorized activities, and that brings us to the offences element. Under the Indian cyber law, the Parliament has now come up with a distinct chapter on cyber crimes. Previously, the IT Act, when it was did not have any focus on cybercrime, but parliamentarians felt that, look, you must come up with the coverage on cyber crimes, and consequently, now a chapter got added in 2000, chapter Roman 11. Then in 2008, we substantially expanded the scope of various cyber crimes that have been now covered within the IT Act. So a large number of activities online punishable with imprisonment and fine. These would include hacking, computer-related offences, obscenity publication, misuse of digital signatures, breach of protected systems, unauthorized intrusion into somebody's privacy, identity theft, publishing or retaining stolen computer resources, knowing them to be stolen, cheating by impersonation by using a computer resource, and of course doing activities which could prejudicially impact India's sovereignty, security and integrity. As I was saying, almost all cyber crimes in the country under the IT Act are covered under chapter Roman 11. A majority of these cyber crimes have now been made as bailable offences, though some of them are non-bailable. Cyber terrorism is one such offence that we added in the year 2008, and it's now a non-bailable, heinous offence punishable with life imprisonment and fine. All police officers of the rank of inspectors can go ahead and investigate cybercrimes. They are punishable with imprisonment ranging from 1 lakh rupees, ranging from 3 years imprisonment to life imprisonment. There's fine provided for. Fine ranges from 1 lakh rupees to 10 lakh rupees. In addition, if you commit other offences under the Indian Penal Code, they will also be applicable to you. So, breach of cyber security incidentally has now been made a specific offence under section 66 of the Information Technology Act 2000. It basically means unauthorized access into somebody's computer system or computer network. You could merely unauthorizedly access, that's an offence. You could go ahead and download, copy or extract data. You could damage a computer system. You could disrupt the working of a computer system. You could misuse of credit card information. You could assist any other person in any of these illegal activities. You can also diminish the value or utility of electronic information. And all of that is being brought within the ambit of breach of security. In addition, the government has been now granted the power to specify certain systems as protected systems. And these protected systems are special systems. You try to unauthorizedly access. I said you try to access. It gets you life imprisonment. So obviously it's a very minimum 10 years imprisonment. So it's very serious exercises. In addition, the law says apart from being booked for cybercrime activities, you can also be asked to pay damages by way of compensation. And these damages can be up to 5 crores in special courts under the Information Technology Act 2000 and beyond 5 crores in a court of competent jurisdiction. Summary proceedings, 6 to 9 months. So these are additional remedies that the law provides. And these are some specific cybercrimes for digital signatures. So you misrepresent when you apply for a digital signature, that's a crime. You breach somebody's confidentiality or privacy, that's a cybercrime. You disclose information in breach of a lawful contract, that's a cybercrime under section 72A of the Information Technology Act 2000. These are broadly stuff on cybercrimes. I will now pause so that we can take questions on evidence, because now I'm going to go on the next session, which will be on intermediaries, but first let's go on the evidence elements, please.
Now, can voice recorded on a mobile phone, can it constitute as a evidence in the court of law?
Absolutely yes. Voice recorded on a mobile phone is nothing but data and information in electronic form. It's recorded by a mobile phone, which is a communication device. It's legal records, can be produced, can be proved in a court of law.
Similar question is about WhatsApp messages and WhatsApp videos and WhatsApp screenshots basically. Can they be used as evidence?
All WhatsApp output is nothing but data and information in the electronic form. That being so, it's all legal evidence, can be produced, can be proved. Any WhatsApp message, WhatsApp video, WhatsApp audio, any SMS, any MMS, any tweet, any Facebook message, any Instagram photograph, any Snapchat message, anything that you can think of in the social media or in the communication media is legal evidence, can be used.
Okay, great. What are the remedies under IT Act or IPC for crimes pertaining to use of online communication modes like email, WhatsApp, etc.?
So if you go ahead and misuse online communication modes like email, WhatsApp, then there are specific provisions like computer related offences is one such offence under section 66 and 43 of the Information Technology Act. That can be done in a variety of circumstances. So if electronic communication is done which diminishes the value or utility, that gets covered under section 66 of the IT Act. 3 years imprisonment, 5 lakh rupees fine. In addition, if your communication is obscene nature, or you give some galis or abuses online, that gets covered under section 67 of the Information Technology Act 2000. 3 years imprisonment, 5 lakh rupees fine. Supposing you take some picture of explicit sexual intercourse happening or activity happening, and you transmit it, it goes on a more serious exercise. Section 67A, and specific serious cybercrime, 5 years imprisonment and fine. You publish child pornography, that child is defined as anybody below 18 years. You even browse child pornography, that's an offence. Minimum 5 years imprisonment, 10 lakh rupees fine. So communication medium has now increasingly been targeted for potential monitoring and surveillance by the government. So if you think you send a message and you think nobody has seen it, you are wrong. And after the 26/11 Mumbai attacks, the Information Technology Act 2000 has been amended in such a manner that huge powers of interception, monitoring, decryption and blocking have been given to the government. So the old dictum is very, very clear. Every man steals, the man who gets caught is a thief. So you have to make sure that you do not transmit any information, if which, when got caught, you get prosecuted under the law. The law is adequately getting it covered. Earlier, we had a far more elaborate and very imaginative section in the form of section 66A of the Information Technology Act. Now that was actually a very, very vast section that said if you sent any information using a computer or a communication device that was grossly offensive or menacing in character, that became an offence. Or it was sending of any information that a person knew was false, but the information was sent for the purposes of causing annoyance, inconvenience, ill will, hatred or enmity persistently by making use of such communication device or phone or a computer. That was also a cybercrime. But in March 2015, in a landmark judgment, being Shreya Singhal versus Union of India, the Supreme Court set aside section 66A as being unconstitutional, as it violated the fundamental right under Article 19(1) and Article 19(2) of the Constitution of India, being a fundamental right of freedom of speech and expression. So now section 66A is not on the law book under the IT Act, but pursuant thereto, we've seen a massive increase in trolling cases, in cases pertaining to online harassment, online abuse, and now recently the government in the Women and Child Welfare Ministry has come up with a new cell which is now only going to look at trolling related complaints, because they are also something but a manifestation of misuse of electronic communications or social media.
Now a person says that I have been accepting all terms and conditions simply by clicking on I'll accept the terms and conditions without reading the same. Does all these amount to a valid contract?
The moment I click I accept, that is a valid contract under the law, because the terms and conditions are only offering you something. It's an electronic offer. You want to take it, you don't want to take it. You don't want to take it, don't click I accept. But the moment you click I accept, you are giving a manifestation of your acceptance of the terms and conditions. So it's an acceptance of an electronic offer that results into a valid binding electronic contract, and that's been granted legality under the Indian IT law. So you have to be very, very careful before you actually click I accept. Otherwise, routinely clicking I accept could expose you to a large number of contracts which you are not even aware of, and which can come and haunt you back in the coming times.
Okay. Now the next question is pertaining to the limitation period. The person says that the contracting party are in different time zones and different countries have got different timelines for limitation. In a particular electronic executive agreement, and the applicable law to the agreement is silent. So for which particular country the limitation period will be valid?
Can you repeat once
again? A
very
technical
because,
kind of a question.
For the benefit of the audience,
yeah.
If we can repeat the question,
okay,
then I can actually address it once again.
Now two parties are entering into an agreement, they are entering into agreement, and the applicable laws to the agreement is silent. How can we address limitation period if the contracting parties located in different countries have different timelines for limitation?
So clearly in such a case, the different limitation laws will be applicable in different jurisdictions. The Indian law is the Indian Limitation Act. That will only apply in India. That will not apply in the US, supposing you have a contract with somebody in the US. In the US, the relevant limitation law will be applicable there. So everything depends on the specific laws that are applicable in each cases. Indian laws, despite the Indian cyber law providing extraterritorial jurisdiction to these laws, are still primarily limited to the applicability within the territorial boundaries of India. So it's not going to go outside India, but yes, in India, the limitation law of India will apply. It will have to be seen what will be the relevant contract, what the time the offer was accepted. That's the time the cause of action starts happening, and the cause of action can be calculated, and the limitation period can be calculated from there.
In the government system, usually we have this kind of a system where personal assistant and personal secretaries are provided, and they handle the email on behalf of the officials. Right? When such emails containing personal sensitive information is assessed by the staff, what are the implications of the same?
The law is very clear. If it is your computer system, you are responsible for the same. If you give access of this to somebody else, your personal secretary, your private secretary, they access it, and tomorrow they misuse it, the responsibility crown is still yours. You will be responsible. You can tomorrow cry hoarse and say, it's my private secretary, you misused the account, no problem. The law may even investigate her. But that may not help you to extricate yourself from potential legal liability. The law says you have to be careful, do not give access to your computer system or your email account to anyone else. You try doing that, and tomorrow there's a misuse, abuse, or there's some cybercrime that's taken place, then you will be responsible. You cannot say, I did not know. In any case, ignorance of law is no excuse in the eyes of law.
Whether all these laws pertaining to cyber or crimes or Information Technology Act, are they applicable to Jammu and Kashmir?
The Information Technology Act 2000 is a law that is applicable throughout the country. So you will have to be equally concerned about it within the territorial jurisdiction of India.
I think we'll let you continue, sir.
Okay. Thank you. I think I now want to take you on to a new paradigm, a new kind of a category that's been created under the law, which is the category known as that of an intermediary. Look at this map. This map gives you various names of companies. These guys are service providers. Because they are service providers, therefore they are deemed to be intermediaries. In fact, the term intermediary has been defined in very vast terms under Section 21W of the Information Technology Act 2000, and this is the definition. Let's read it together how it goes. It says intermediary with respect to any particular electronic record means any person who on behalf of another person receives, stores or transmits that record or provides any service with respect to that record, and includes telecom service providers, network service providers, internet service providers, web hosting service providers, search engines, online payment sites, online auction sites, online marketplaces, and cyber cafes. Now I want to pause and ask you, the company that you're working for, does it become an intermediary? The client that you're advising, does it become an intermediary? Today, invariably, any client, any company is using data and information in the electronic form. They're using computers, they're using emails, they're using mobile phones. And the company would invariably tend to give an email account to its employees. So the company definitely, with respect to particular electronic records, is a legal entity who on behalf of another person is receiving, storing or transmitting that record. The company becomes a network service provider, and hence they become an intermediary. So my reading is the way they've actually gone ahead and defined intermediary is so vast that 9 out of 10 companies in India qualify as intermediaries. The moment you become an intermediary, there are some statutory responsibilities that are attached on you. You are mandated to exercise due diligence while you discharge your obligations under the law. And various parameters of due diligence have been defined under the Information Technology Rules 2011 per se. Of course, the documented due diligence must be done. You must have papers to show that these kinds of compliances you've done. So what are these compliances? You need to have in place your terms and conditions, your rules and regulations, your user agreements, your privacy policies, to ensure that you've informed all of your users that what kind of activities they can and they cannot do on your computer system. Further, if you are handling or processing sensitive personal data, then you are further required to go on and have additional set of compliances to be done. You need to have in place policies pertaining to data protection, data preservation, then data retention, data archiving, and a variety of these activities per se. What happens if you don't comply? Because in India we have the Jugaad school of management. Everybody feels that they can do Jugaad and get away with it. My practical experience tells me that doing Jugaad in the cyberspace or in the context of IT acts becomes very, very difficult, because you will have to fabricate false electronic records, which becomes a separate crime altogether. So if you don't comply with these requirements of due diligence, and if you do not do your compliances for the companies under the IT Act, there are two kinds of liabilities. You can actually be sued for civil and criminal liability. Civilly, you can be sued for damages by way of compensation, up to 5 crores under the IT Act, under the special courts under the IT Act, and beyond 5 crores in a court of competent jurisdiction. In addition, your top management could be exposed to criminal consequences. They could be sent behind bars. They could have imprisonment ranging from 3 years to life imprisonment, fine from 1 lakh rupees to 10 lakh rupees. So, in addition, there's a huge reputational aspect of a loss of reputation, goodwill, standing or repute to your company in case if your matters pertaining to non-compliance with the IT Act tends to get notified under the media or under the public consequences. So therefore, an ISO 27001 is one such standard of checks and balances in the form of having in place reasonable security practices and procedures when you as a company are dealing, handling or processing sensitive personal data. The good or the bad news is that India has got very less number of cybercrime convictions, primarily because it takes a different challenge altogether to collect electronic evidence, then to preserve it, and then to produce it in accordance with the law in the country. Well, these are the kind of work that me and my law firm does. My law firm Pavandugal Associates works on the intersection of law and technology. In fact, we specialize in cyber law, cybercrime law, cyber security law, mobile law, intellectual property rights, anything to do in the commonality of law and technology. And this is what other people talk about us. And I think every day for us is a new day, in the sense new technology, new things emerging, having new legal ramifications. And consequently, this morning I was just reading the news. The recent shooting that took place of some some people in police firings. The police had actually used an automated robot for the purposes of firing some of the concerned people. So now you're going to look at more use of robots, artificial intelligence, Internet of Things coming in, and we've been working in these niche areas. So we work with the government, we work with the private sector. I do a lot of litigation myself in terms of representing various clients, and we advise and assist all our clients and all intermediaries and companies in their various compliance requirements in India per se. I also at this juncture want to mention to you about this international conference that we do every year. This is the International Conference on Cyber Law, Cybercrime and Cyber Security. Well, this is an older slide of 2014, but this is where we began. Today it's much more bigger. This year it's being actually held on 17th and 18th of November 2016. With basically this conference is aiming to analyze the newly emerging thought processes, trends in the areas of cyber law, cybercrime and cyber security. You can have more information about that on the conference website, which is cyberlawcybercrime.com. I think I want to pause here and ask for some further questions.
I'll take just 3 questions here.
Sure.
What are the precautions which must be taken while video conferencing? There are board meetings which are held through video conference these days. And what are the precautions in a distributed kind of environment where multiple people are sitting in different areas?
Well, the first precaution that you must take is you must record the video recording or the video conferencing the entire session. Why? Because that's the first record to show what transpired in the video conferencing session. Number two, when you take the recording, please save it on a CD or on a pen drive, and please get a certificate under Section 65B of the Indian Evidence Act from the relevant computer operators who were operating the video conferencing facility. Why? Because they will have to certify that this video conferencing session was done and was recorded as it is. They will have to actually elaborate the methodology of how they recorded the video conferencing session, and then they will have to certify that there has been no tampering, addition or alteration of any kind whatsoever. Once you have these certifications in place, you can put them aside and then continue with your daily stuff, because tomorrow there's going to be a conflict or a controversy, or somebody disputes that I didn't say this in video conferencing. Then your video conferencing records will be able to give information of what was actually said or not said. In addition, it's always nicer, and a lot of companies today do it, that they transcribe whatever has been stated on video conferencing and then circulated that also within the members of the board of management present, so that it's an added confirmation of the fact of what really transpired. But ultimately, video conferencing is nothing but electronic output. It's electronic data. It gets covered within the definition of computer output under Section 65A and B of the Indian Evidence Act, as amended by the Information Technology Act, and it is required to be certified by a person occupying a responsible, efficient position with respect to the working of the relevant video conferencing mechanism, devices or computers. So have those precautions in place, and then I think you're ready to go.
Okay. There's a question regarding, is there any law governing email marketing campaigns? Is it legally permissible to send out mails with unsubscribe option?
First and foremost, India does not have an anti-spam law. In the sense, spamming is not illegal in the country. Spam is sending of unsolicited email. So consequently, what's happened is India has now become the biggest spamming nation in the world. The maximum number of spams across the world originate out of India. So unfortunately, even the IT Act does not talk anything of spam. So if you're sending a spam, you can do so. People may tend to get irritated. It's always good practice not to engage in spamming, because in other countries spamming has been made a criminal offense as well. But in India, it's not an offense, though if you spam somebody too much, they can sue you for damages. In addition, you can always send an email and give an unsubscribe option, because if the individual really wants to unsubscribe, he will unsubscribe, and then you will ensure that he does not get revisited by your constant communication. But in the absence of legal frameworks to govern email sending and spamming, you can continue to do what you are, but be careful. Sometimes excessive spamming can actually expose you to potential legal consequences, not only in our own country, but also in the outside country where your spam is being received. I have done cases where clients spammed and they got prosecuted in other countries under their anti-spam laws. So be very, very careful, because the internet has made geography history. It's a global village now. So you can't say, I was spamming within India, and even if though the spam went outside India, I cannot be tried outside India. Today, increasingly, we are seeing cases where people are being prosecuted under national laws of different other nations outside their own territorial boundaries of their own country.
There's another question on Contract Act. How Contract Act supports the data protection law in India?
Well, Contract Act is an old act, and it provides for all the basis for contracting. But it has not yet been amended by the Information Technology Act 2000. So consequently, we just make it the provisions of the same applicable in the context of the electronic ecosystem. But almost all contracting principles are equally applicable in the context of electronic contracts. Thanks to the amendments in 2008 in the Information Technology Act 2000, the IT Act now says that an electronic contract will not be discriminated against only on the ground that it has been entered into in the electronic form. So therefore effectively means that all principles pertaining to contracting as are detailed under the Indian Contract Act are equally applicable in the context of electronic computing and contracting. Of course, in case if there's a conflict between the IT Act and the Contract Act, then in those events of conflict only, the IT Act will prevail. But barring this, all principles of Contract Act will be applicable to electronic contracts.
Okay. And this is one of the most asked questions which I am asking now. Now, many of practicing company secretaries, they want to make the cyber law as one of the areas in which they can work. Company secretary is one of the key managerial person. So, how he can take advantage of this kind of a IT-enabled environment and move into this particular area or explore working in this area. In this particular thing, I must inform all the viewers here that Mr. Pavan Dugal has written an article on this particular subject, which is available on the website of the institute, which is icsi.edu. I request you all to go through it. Sir, this question, sir.
Thanks. I think this is a very proactive and progressive question, because today now increasingly cyberspace is coming all across. Internet is now an integral part of our lives. Electronic format is the de facto legal format. So therefore it makes logical sense for you as a company secretary to start exploring and looking and going in the area of cyber law. Why? Because you are your first port of call for the company. The company is going to ask you, sir, we are into electronic format, please guide us for cyber law compliances. So it will always be a good idea that if you can actually beef up your skills and get yourself orientation in cyber law, so that you can actually inform your respective companies in this regard. In addition, if you ever require any assistance, I am always available. I'm going to share with you my email at the end of this session, and it's on this PowerPoint as well. But I'm very simple. My email ID is pavan@pavandugal.com, and I spell Pavan with a V. It's Pavan @pavandugal.com, PAVANDUGGAL.com. And another ID that you would like to have is pdugal, PDUGGAL @vsnl.com, V for victory. I will also share these IDs. Should you ever require any inputs, any guidance from my side on issues on cyber law, I'll be very happy to provide. But yes, this is an urgent requirement. You as company secretaries must now be beefed up, must be aware, and therefore if possible you should do some cyber law programs so that can give you more in-depth nuances. It looks very, very simple. You know, when you read the IT Act, it's a small legislation, 90 sections. And you say, wow, I can do it in a couple of hours. But there are so many nuances, there are so many black holes under the IT Act. It takes you a lot of time to understand the nuances. So it's nice if you can go through some course, and if the institute can offer some course, that would be nice. And in addition, there are some private courses being made available. Some universities in India are offering these courses. Doing any of these courses will help enhance your understanding on cyber law, because increasingly now you will be asked as the first port of call, for your first point of contact with the company, more about issues of compliances under the law. And mind you, these compliances are now no longer directory, they are all mandatory. Non-compliance with the compliance requirements ensures potential exposure to criminal and civil consequences. So please go ahead and get more and more prepared, because the future belongs to cyber, and therefore the electronic ecosystem nuances must be fully dealt with by professionals like company secretaries, and they can obviously take assistance from lawyers in this regard as well.
Okay. Pavanji, you have been holding international seminars for a very long time, and you are also one of the directors of one such seminar. What can the students and members expect in this seminar which is coming in this particular year?
So we are doing this international conference on cyber law, cybercrime and cyber security. Till now we were doing a one-day conference each, so the last many years. But there was a demand that we needed to expand the conference. Why? Because the last conference that we did in November 2015, we had 108 speakers, we had 18 sessions, there were 6 plenary sessions, there were 3 parallel tracks. A lot of people said, I required more and more time, and I was spoiled for choice. And therefore we this year are doing it on a 2-day event. This year we are expecting far more. We are expecting more than about 500 to 600 people coming in for the 2-day conference. We are expecting to have people from a variety of countries. Already we have about 30 plus foreign speakers who have confirmed, who are expected to be coming in for this conference. The conference is being supported by the Ministry of Communications and Information Technology, the Ministry of Justice, Government of India. In addition, We're also being supported by international organizations, by UNESCO, ITU, and a variety of universities and other academic and professional organizations. So from the perspective of the institute members, I think here is a fascinating opportunity. So if the institute can ensure that a lot of its members can come during that 2-day conference, I can tell you, in those 2 days, assuming you come with a blank slate, at the end of the 2 days, you would be far more well informed than a lot of your peers about various nuances pertaining to cyber law, because we will be dealing with cutting edge nuances and we will be dealing with practical case study based approach, where in today's world nobody wants gyan. Everybody wants how does it affect me and how can actually I take benefit out of it. So if these 2-day programs, if the institute and its members can come in, and we can definitely work as a conference director of the conference with the institute to give a kind of a special offer in terms of the rate and the pricing for the members. I think it will be a fabulous opportunity. Not only it's a great opportunity, you get to meet more than 500 odd people in 2 days, all dealing with cyber, the creme de la creme in the world and in India. More so, you establish immense number of new contacts, because here all kinds of people come in, all companies come in, government departments come in, regulators come in, law enforcements come in, international agencies come in. So it will be a fabulous opportunity, and especially in the light of the last question, where more and more now company secretaries want to get cyber law savvy, this is a fabulous space. And considering that this conference is also substantially focusing on cyber security and connected legalities, you would in 2 days be exposed to tremendous, shall I say, knowledge, tremendous wealth of contacts and networks that you create, and it's a fabulous opportunity. This kind of a conference is not being held anywhere in this kind of a format anywhere in the world, and I think our endeavor is to get the best and the creme de la creme together. So we'll actually request the institute, we can work together and give some offerings to our members. It'll be a pleasure to welcome all of you to the 2-day seminar.
Well, before we let Mr. Pawan give his finishing remarks, I'd like to introduce some more aspects about Mr. Pawan. Mr. Pawan heads his niche law firm, Pawan Dugal Associates, which has practice areas amongst others in cyber laws, business process outsourcing laws, intellectual property rights, and information technology laws, information security law, defense, biotech, and corporate laws. He has been a member of the Nominating Committee, Membership Advisory Committee, and Membership Implementation Task Force of ICANN. Pawan is also the president of cyberlaws.net, which is Internet's first ever unique cyber law consultancy. In addition to that, he is also the founder of Cyber Law Association and also the founding president of Cyber Laws India. Some outstanding pioneer work in the field of BPO legal issues has resulted in his being a member of the BPO steering committee of SOCHM. Today he advises a number of BPO concerns on different legal issues relating to outsourcing. Pawan was the chairman of the Cyber Law Committee of SOCHM and works closely with CII and FICCI. Pawan is a regular on the lecture circuit also. He has spoken at around 1200 conferences, seminars and workshops in the last 7 years and has lectured exclusively in select law colleges. As a writer, he has made his mark with 75 books on various aspects of laws in the last 15 years. He has contributed a continuing weekly column in diverse aspects of law titled Brief Cases in the Economic Times for the last 7 years. Mr. Pawan, you can have the last word now.
Thank you, Mr. Yadav. This has been fabulous. Thanks for those kind words. So, the last words are very clear. You guys are the masters. You are the gurus of your profession, of your working. I am only here as an enabler, as a catalyst to inform you that the Indian cyber law is governing all your activities. You don't need to be a lawyer to know this. The moment you use electronic format, you use computers, computer networks, communication devices, and mind you, if you use these, you are definitely under the cyber law. Why? Because these are not just small mobile phones. These are working computers. This phone that I have in my hand has more computing power than the computer that was sent, that was used by NASA to send man to moon. So that's the kind of computing power that all of us are holding in our hands. So we'll have to be alive to the fact that Indian cyber law has created the appropriate legal framework for promoting e-commerce in the country, and also has and was giving legality to the electronic format. The said legal lead, well, it's a typo there, it should be legal format, has provided for various enabling legal provisions that provide for electronic authentication and cybersecurity related issues. And all legal entities have to ensure that their business operations need to comply with the parameters of the Information Technology Act 2000, as also rules and regulations made thereunder. I and my law firm Pavan Dugal Associates assist large number of companies, large number of professionals, company secretaries, cost accountants, chartered accountants in the compliances. So if you tomorrow require any assistance on any cyber law compliances, feel free to reach out. One will be very happy to assist you in this regard. The final words, it's, you see, the IT Act is something like, I'm reminded of the famous Mahabharat epic. In Mahabharat, when Lord Krishna was giving his Gita discourse, he had one common theme. The theme was, you come to my Sharan and I will take care of you. I think the Indian Information Technology Act has a similar message. You come inside my ambit, you comply with my provisions, and I will ensure that no harm will befall upon you. And therefore they say, it's only in compliance, compliance and compliance lies the way for nirvana, for all the stakeholders in the digital and the mobile ecosystem of today per se. And with that, I come to the end of this webinar. I'm here giving my email IDs. You can have my official email ID, which is Pavan, P-A-V-A-N, at pavandugal.com, P-A-V-A-N-D-U-G-G-A-L.com. There's also Yahoo ID, my name, Pavan Dugal, P-A-V-A-N-D-U-G-G-A-L, at yahoo.com. I'm available all the time on email. Feel free to reach out. This is a fascinating area. All I can say in conclusion is that cyber law and data protection are increasingly going to become center stage in our day-to-day lives, whether we like it or not. We are already using WhatsApp. WhatsApp is already giving you end-to-end encryption. Well, all that is data protection. It has got legal ramifications and therefore it's got cyber law. So the fact is, very quickly, cyber law is already impacting all our existing, potential and future business activities. Therefore, you as the compliance professionals in your respective industries, your respective clients, your respective practices, you'll have to increasingly sensitize your clients that please ensure compliance with the Indian cyber law. Good, bad or worse, that's the law of the land. You must be in compliance with the same. If you comply, then the Indian cyber law says, I will also give you complete protection. You can still be sued, but I'll make sure that you don't even part 1 rupee as damages by way of compensation. None of your top people or anybody in your company goes to jail. That's a kind of a guarantee that the law provides you, provided you comply with the law. And of course, there are a large number of compliances that have been specifically stipulated under the Information Technology Act 2000 by various rules, regulations, notifications, directions and orders given by the Government of India from time to time, primarily also including the Information Technology rules of 2011. So please sensitize your companies about these compliances under cyber law. Please get these compliances done. In India, majority of the companies do not comply with the cyber law. But my suggestion is, you should be exception to the general rule, comply with cyber law and then be nischint, be without any kind of headache. Why? Because tomorrow, you can't even predict what's the kind of a next digital challenge that's going to knock your doors, or what's going to be the next digital problem that your company is going to be. And tomorrow, once there's such a digital exigency or emergency happens, it's going to be too late. You may not be even in a position, or not even have enough time to go ahead and do the requisite compliances in this regard. So please comply with the law. And I like to end with a final analogy that I like to give. See, when I'm going out of my home, this is monsoon time. It's about to rain. I'm asking you, please carry an umbrella. Why? This umbrella is going to ensure that if it rains, it will protect you and will ensure that you will not get wet. But if you don't carry your umbrella, there are 100% chances that you will be wet. Your compliances under the Indian cyber law are the umbrellas that I want you, as the compliance officers of your companies, as the company secretaries, to have and carry for yourself, for your companies. Now, a lot of time, you as company secretaries will have big firms, you'll have practice areas, and you have variety of people working for you. Remember, you as company secretary also become an intermediary. So independently of your clients, you as your practice must also ensure compliance as an intermediary under the Information Technology Act. It's always better to have this umbrella that's going to protect you from untoward, undesirable and unforeseen circumstances or legal consequences that will come to you. But this is a fascinating space. Law is constantly evolving. It's evolved massively, but it's only at a very initial stage. If we were to write a book on cyber law in 2025, in 9 years from now, then if the book was to be of 100 pages, then in 2016, we've only reached to the 9th or the 10th page. The remaining 90 pages of the book have yet to be written. That is the kind of the development that is yet to take place in cyber law. This is a fascinating space. Please be an integral part of the cyber law developments. Get yourself constantly updated and be always on the right side of law. It's a pleasure talking to you at this webinar, and thank you, Mr. Yadav, for giving me this opportunity for addressing your remarkable group of people and your members for the Institute. Congratulations on the remarkable work, your thought leadership that you're doing at the Institute, and I'll be more than happy to provide any inputs for the Institute and for all its members.
Thank you, Pavanji. To all the members and the students, there has been constant demands from you regarding knowing more about cyber laws. I think we have fulfilled your demand. One of the demands was that we have only reached 5 to 6 cities through the seminars. Now we have reached to each and every part of the country and across the country borders also. We are thankful for your support, and we hope that in future also we will be getting queries and guidance from you on what are the important aspects pertaining to the law. Thank you very much for the day.
Thank you.